Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this afternoon I'm looking at a book which has come to us from Spiramus Press. And this is on ADR, Alternative Dispute Resolution, specifically and trusts. So it's called ADR and Trusts. And it's got a subtitle, an international guide to arbitration and mediation of trust disputes. And it's been written by two people, Jones and Peter Pexton. Now, my wife and I have looked at this book, had a chat about it, and we've come up with a title, A First-Class Guide to Settling Trust Disputes Without Litigation. And that's what the purpose is. There it is. It's got a red cover. You find some of them have green covers, but it is actually a red cover. This is the book itself, spine. Then at the back, you've got some detail about the authors, what the content is, and then a little bit of detail about Spiramus as well. Again, at the back, you have a standard type of index, which is very helpful, lists the countries as well that are included in this. Then you've got the work itself, and let me just give you an example of what you've got. You've got paragraph numbering, if I can find it there. There we go, paragraph numbering, you can see there. There are some very few footnotes, but there are some footnotes. But the paragraph numbering is quite helpful. You can see it down again at the bottom there. Then if we go to the front, there's the front page. Then you've got a nice little dedication. I like to show the dedications. Then there's a foreword by Geoffrey Shindler, which is well worth reading because it sets the scene, and I'm going to mention that in the review. Then you've got the contents, content part A and so forth. Then part B, which is on jurisdictions, and it looks at the various countries that they've picked. Again, you can see just flicking through it what you've got. Then there's some case law, which is always useful. There's statute law as well. Then you've got introduction to dispute resolution. You've got a list of abbreviations which I think would be helpful for people involved in conventions and various other things. But the introduction is very helpful. It's worth reading because it sets the scene quite nicely, and then you get into the book itself with the paragraph numbering and so on. The book is about 370, 80 pages, under 400 pages. It's a paperback. And I've been quite pleased with it because ADR is very much the future. It's where we are at the moment. It's very popular with a lot of people for a lot of reasons. I mean, one of the problems I have is that the people I often represent have absolutely no wish to mediate anything. And in those circumstances, I'm afraid you have to have a trial, and then a decision has to be made one way or the other. Anyway, let me talk about what the book contains, because trusts law, the law of trusts, is always a fascinating area, and one that I'm sure most people who've been undergraduates doing an LLB would have found very interesting, because a lot of cases in it, a lot of human interaction, a lot of interesting behaviour, if I can put it that way. More of that in a minute. Spiramus Press have come up trumps again, we say, and with this new important work on settling trust disputes without having to go to court. And that's what this is about. In just under 400 pages, Jones and Peter Pexton have produced a helpful guide to assist professional advisors who want to assist their clients without resort to litigation. The title emerged from the Jones and Pexton mediation courses run by the Society of Trust and Estate Practitioners. So they've basically been able to develop what they did with the courses, and I've attended some of these mediation courses, and very good they are too, but they've been able to develop it into the form of a book, which is actually much easier because you can sit down, read it, and get some ideas about how you might deal with a particularly thorny issue. In his foreword, Geoffrey Shindler writes that, quote, with all the uncertainties in the present world, two matters are certain. There will be more and more disputes over trusts as the older generation who created the trusts in the latter part of the last century die, and sibling rivalry and grievance comes to the surface. And secondly, the cost of conducting those disputes will increase exponentially. We've certainly seen that in the second decade of the 21st century, where costs are of crucial importance, and there are big increases in fees for any matters that have to go to court and so forth. So therefore, it's looking at an alternative way of dealing with it, especially in an area where you do get a lot of unpleasantness. And that is one of the facts of life, I'm afraid, where a trust is set up and people sometimes don't like what the settlor had in mind in the first place. So there we are. Let me continue. How right Shindler is with what he says then in the introduction. He concludes that the book is both deep and wide, and he recommends it heartily to all those involved in this possibly distasteful part of trusteeship, adding that it is but equally an increasingly common part of it. So you see what the difficulty is. We do have this issue concerning a problem which, again, can cause an awful lot of difficulty. So mediation is probably a good way round it rather than going actually to a court itself. The reality of trusteeship and ADR will always be difficult when the beneficiaries may be minors, contingent or even unborn persons. But as Shindler points out, the way the courts have developed a method of tackling disputes without recourse to the court is to be desired and encouraged, and I would say hear to that, and I'm sure most would. We're certainly now in the age of ADR, and we feel this book has a much wider appeal than to just the professional advisor. Spiramus Press continue to provide both practical and professional titles covering tax, accountancy, finance and business law, and this international guide to the arbitration and mediation of trust disputes is actually an easy to read book which has the detail both advisors and clients will need when disputes arise. There are two parts to the book, as I showed you earlier. Part A has 12 chapters, followed by 4 excellent practical appendices. So the appendices come immediately after Part A. Then, what you've then got is it looks at the various forms of ADR and examines the differences between arbitration and mediation of trusts and fiduciary disputes. Also included are some useful suggestions about how to avoid disputes, with a clear statement on the role of professional advisors and the mediation techniques which are going to be used, which have been developed from the courses which the authors have presented. Now the second part, Part B, covers jurisdictions, and that's from page 135 onwards. It runs to 27 chapters covering the main countries involved, including how trust law and ADR operates in each of them. The content for each country covered includes arbitration law and practice, trust law itself, the mandatory requirements for mediation, and finally enforcement. So for those readers relatively new to ADR, it's a good idea to read the main introduction first. I certainly found it very helpful to look at. Many advisors and lawyers have now done some additional training on dispute resolution, apart from what you of course did on your bar course or whatever, although it can appear a trifle confusing until one has understood the system and how it actually operates. The authors, who are natural born mediators themselves in our view, say that conflict is ever present in our daily lives, but from the earliest times different methods have been employed to bring about peaceful solutions. And that's really where we are today. We found with clients that there is some confusion and wariness over ADR. This book actually goes a long way to alleviate the many worries and concerns which have been raised in recent years, and it's a prime guide for the trust specialist as civil justice continues to be reshaped in the next few years, because we're entering a new era with the way we do our court business at the moment. There's the book again, front and the spine, just opening it in the middle anywhere. This is Australia, start of jurisdictions, and it starts off, it's alphabetic, so it starts off with Australia number 1 and sets out what the policies are there, and then you run all the way through. Canada is included, and then a whole range all the way through Isle of Man and so forth. All the usual suspects are there, if I can put it that way, as to where trusts might have been established. Then in the basic first part, you've got obviously the referencing, paragraph referencing, not very much by way of footnotes, a little bit there, for instance, and so forth. I thought this was a very good book, and certainly for anybody, we're all doing much more ADR today, and I think this is one, if your practice is predominantly in equity and trusts, this is an area I think you'll find very helpful. So thank you very much to Grant and Peter for producing this work. I'm delighted with it. It's a great addition to what we have from Spiramus. It's easy for the general readership too. So thank you to all concerned for an excellent book. Bye-bye.